behind here.
Right here, everybody.
Allow me first to thank all of you for being here this afternoon. We have chosen an amazing day. We have the most beautiful snow outside. And it's amazing to look at it and enjoy it, not walk in it. So today it shows your sincerity and dedication to the subject that we are about to introduce to you. So thank you all for being with us this afternoon. I can tell you that I am ecstatic to have the most wonderful speakers with me today. And hence I have this to show some power that they do every day in their everyday life. Our speakers today are the most powerful women, and this is one of the themes that we are going to be talking about. As you know, here at the UN and everywhere else around the world, the issue of empowerment of women is very important. And this is to show the world what are these amazing women are capable of. As I am proud to be part of this organization, which is the National Association of Women Judges, that has judges including Ginsburg, that I'm sure all of you have been watching the movie or seen the movie on her life. As also we have the most dedicated, close friend ambassadors who are honoring us by being here with us, and they also would like to say a few welcoming remarks to all of you and to our guest speakers. I will begin to introduce the amazing ambassadors. I will start with His Excellency Mr. Modeste Johnson Miru. He's the ambassador of the permanent representative of the United Republic of Tanzania to the United Nations in New York. Mr. Miru has been a chair of the African group in Geneva and has been the ambassador and the permanent representative ambassador extraordinaire and accredited at the IAEA, UNOG, UNIDO, CTBTO, UNODC, and CFC. He also has been here in New York, and he has an amazing, lovely wife who happened to be my friend. I have to give her a plug as a woman. And and they also, in Tanzania, the president of Tanzania has hosted all of the international women judges in Tanzania, and we were very honored to be there, and he was the most amazing, gracious host. They took good care of us, and we were like over 1,000 some people there. So please give a big welcome to Ambassador Miro. Yeah.
Thank you very much, Sally, for this amazing introduction. You are so kind. Thank you so much. Madam President, distinguished eminent judges in front of me right now, colleagues and friends, welcome to this meeting of the International Federation for Peace and Sustainable Development. We are pleased that you could make it, much as the weather is not very friendly. It's too snowing there, but you found your way in this room. We are also all very grateful for the contribution you are making in defense of the right of juvenile, women, children, and above all, by guaranteeing the rights of everybody under the rule of law. All of us, everybody. You've been there for many years, and you have a lot of experience too. Peace and security is very important for all countries in the world. The same apply to the human right. With peace, we can guarantee sustainability of our development and ensure socio-economic development of our countries. We are grateful that we have honorable judges with enormous experiences serving our communities amidst their busy schedule have joined to this meeting. We are proud of these honorable judges for ensuring that women are taking leadership in the administration of the law. You can see in front, they're all women. We are here kindly going to listen to you carefully so that you can learn from your experiences, and we look forward to have a very engaging meeting that will ensure that we come out with a lot of experience that we've borrowed from them. And I thank you very much, Sally. Thank you.
Thank you, Ambassador. And now it's an honor and a privilege to introduce our next speaker, welcoming guest, who will be saying few welcoming remarks as well. He is a very dear friend to myself and to my husband, so we'll forgive you for that. His Excellency, Mr. Skinner Lee, is the permanent representative of Guatemala to the United Nations. He served as Guatemala ambassador to Belgium and Luxembourg and chief of mission to the European Union from 2012 till 2012. Previously, His Excellency was the country's permanent representative to the Organization of American States and Vice Minister of Foreign Affairs in 2004. Please welcome a big hand to our dear Ambassador Jorge.
Try to be brief. First, snow is like the law. It's nice to watch, but difficult to deal with. And it gets dirty too at times, but that's a nature thing. Secondly, thank you for inviting me. I have very few things to add and a lot to learn actually. But one of them is that how much we push for ODS 16, MDS, which is societies that are inclusive, resilient, and certainly inclusive. We have dealt with this problem very often at home, just as in Tanzania with so many ethnic groups. And how do you really encompass them? How do they make a life in the legal world, which is still a challenge? Access to justice. It's probably one of the greatest challenges we have. We have tried different ways, even with the so-called Impunity Commission, which not necessarily is an example, but it can be something to appreciate how human folly sometimes gets in between. The law is one thing, but the judgment is different, and the way we proceed as human beings. But I am here to share experiences with the judges, just more than that to learn, although it's with trepidation that one sits before a judge, let alone several. So thank you for that, Sally. Thank you.
Thank you, Ambassador. Now I would like to introduce my honorable guests. As we all know, this is the subject, the Secretary General's report on addressing inequalities and challenges to social inclusion through fiscal, wage, and social policies shows that global inequality levels remain very high and that inequality within countries has been rising in many regions of the world. Indeed, studies indicate that the gap between the very rich and the poor countries have widened. Today, we will shed a little bit of light on the law that maybe can bring all of this together. And I will start introducing one of our wonderful judges, they all are, but an honor to introduce to you the Honorable Judge Amy L. Nashtem is the Chief Justice of Massachusetts Juvenile Court Department. As the Chief Justice, she advances the administration and management of policy and practice affecting juvenile justice and child welfare in the juvenile courts of women judges, NAWJ, the country's leading voice for women jurists, committed in diversity, equality, and the system of justice. She has served on the NAWJ board of directors for over 15 years, and she currently serves as the Juvenile Child Welfare Committee. She was awarded the Justice Joan Dempsey Klein Award and speaks nationally in issues relating to youth and family. Please give her a big welcome.
Good afternoon, everybody. What a pleasure and an honor to be here. And Madam President, thank you for your gracious and welcoming remarks, and to Mr. Cater for welcoming us into your home across the street, and at your offices and in your home here, and to both the ambassadors and the number of staff and others that are working here. Thank you also for your gracious welcome and your warm hospitality. You know, when I read about Madam President, Ms. Cater, Sally, because she's my friend as well, her accomplishments are just outstanding, and has done so much to blaze a trail regarding human rights and women's empowerment, as well as human trafficking, and works in all types of leadership for women globally. So it truly was an honor to be asked to be with you here today, and a privilege. We met through our association, through the National Association of Women Judges. Sally spoke of it just briefly. I wanted to touch on it ever so briefly, but it's very important for me to share this with you. The National Association of Women Judges is the leading voice of women in the judiciary, and our mission at the National Association is truly to advance and promote the judicial role by protecting the rights of individuals under the law, just what we've been asked to speak to you today. We are a strong, committed, and diverse judiciary. And we were created only in 1979, so we're celebrating just about 40 years. We started only with a handful of women judges back in the day. Joan Dempsey Klein, who you heard, was the co-founder with Vano Spencer at the time, an African-American woman and a white woman, founding a very diverse organization. I wanted to add that we are now grown to almost 1,200 or 1,300 women from across the country. And just briefly, because I want to stay on topic today, I want to mention that what grew out of the National Association of Women Judges was called the International Association of Women Judges. We are now in 85 countries with over 6,000 women jurists. And together, so as you say, Mr. Ambassador, women are starting to rule here. We are working to promote together and empower women judges worldwide. We didn't always have such a strong voice, and to work to uproot gender biases, discrimination in education, which we're going to talk about today, and promote human rights. So I wanted to share that with you, because on your program you see NAWJ, and I wanted you to know a little bit more about who we were. I want to also talk about, today I've been asked to address issues regarding the world of juvenile justice and child welfare, youth in our system. As Chief Justice of the Juvenile Court in Massachusetts, we're a statewide system, and along with 43 judges in Massachusetts or so, our responsibility is to administer justice relating to child welfare and juvenile justice. It is an area of practice that focuses truly on the best interest of the child and equity for children. And what I learned early on in this practice, prior to becoming a judge in this area, I was a prosecutor prosecuting child abuse and issues of human trafficking, other others that affect our youth, resolutions and the resolve for these children come from communities, come from not just the courts, but from educators, from council, from all of us in our international and national community. It is an interest of mine and an initiative of us in Massachusetts to increase permanency for children that find themselves in our system. Because the children we see in the juvenile justice systems are children that have been likely removed from their homes due to abuse and neglect. And you can imagine when that happens, what also happens, that they are uprooted educationally. And today we want to focus on and how to increase the equities in educational outcomes for all children. And for our focus, for my focus, and those that practice in child welfare, it's about providing these young people with stability and permanency so they don't have to move around and be uprooted by, due to circumstances beyond their control in child welfare. So I was thrilled to have an opportunity to speak very briefly to you about some of the social inequities, the educational inequities that we have seen in the law and that we are trying to fix in the law as well, as we look to improve our outcomes for children. We are also concerned about the numbers. Across the country, there are over, I believe the number is well over 400,000 young people that find themselves in circumstances of child welfare. And of that number, many of them are very, very young children. And we see and focus on some racial disparities that we are looking to improve by our work and advancing the rule of law. One of the key goals for us in the nation and internationally is to support strength-based strategies to ensure that these vulnerable populations of children do not penetrate into our system. We have to divert them from the system, and rather than perhaps fixing a family, as it were, once they come into the system, it is our responsibility to intervene as a community earlier, to provide those supports for families in needs, to provide them with the resources that they need to succeed academically as well as emotionally and socially. Regarding education, I did a little bit of research on education in this country, and I was, well, a little bit surprised to learn that in the United States, education is not a fundamental right. In fact, education is not even mentioned in the United States Constitution. Federal laws have particularly declared that the right is not fundamental but ever so important. And states, this has trickled down to states and localities to ensure that there is equal access to education. You're all familiar, or many of you are familiar with Brown versus Board of Education, changing the way we look at equal rights for education in this country. And equal opportunities vary from state to state. And it varies as a result as well to children that have stability at home versus children that are in the foster system. And as I said, the numbers are huge in the United States in child care, and we're working as collaboratively with our communities as possible to ensure their well-being. The good news in much of this is there are many reforms that are happening federally as well as locally. The Every Student Succeeds Act of 2015 is a federal act that looks to establish systems to ensure accountability from each of our school systems to ensure that children have equal access to education. We are now currently looking at a Family First Act, which affects child welfare, in that all of our states must look at preventative methods at home before children are taken from their home. And that means as early as birth and to 3 years old, before these children are in the system. So there's much to be excited about locally, statewide, and nationally. Public education is a critical pathway to those families that are in the below the poverty level. It is important that these young people stay in school. In 2016, there was more than 75% of our lower income 4th through 8th graders nationwide, they could not read at a grade level. Imagine the work that we need to do to ensure that they are at grade level. It is important that our children have equal access and opportunity. So we have to respond with solutions, and we are responding to solutions. In Massachusetts, we are the first in the nation to create what's called a leadership forum. And this leadership forum is a multidisciplinary team of educators, of police, of prosecutors, of the judiciary, of community leaders, of legislators who are coming together to discuss those areas of most concern for our youth. We are looking and aiming to increase literacy, increase permanency, and decrease the number of youth that are called dually informed and involved in the system. That means children that get into the child welfare system oftentimes find themselves in the criminal justice system because they do not have the stability and well-being at home. We're looking to change that trajectory. We are working to increase school stability. I'm trying to talk as fast as I can. In equitable decrease, because I'm aware of the time, Madam President, and chronic absenteeism. And it is important that we decrease school exclusion. And it used to be that children were expelled for behavior in schools or bad behavior in school. We now know and always have known there's no bad kids. There are issues that are behind the actions that kids will use in school. So children are no longer driven from school as a result of some of their behaviors. And that's an important national shift. Our national shift is also looking at positive youth development, supporting children, hearing their voice, asking them why, and not just assuming we know what is in the best interest of children. And that's affecting how we see them in the system. It's affecting their education and their better outcomes for education. It is also something I wanted to touch on just very briefly, is that there are alternate resources in the community as well for education, resources available. Massachusetts has instituted a sort of a hybrid, not a criminal a path and not a child welfare path, but a child requiring assistance act, which we ensure that we wrap around services in the community and ensure they are paired with the proper schooling so they can survive well. In Massachusetts, we have new criminal reform legislation that has stricken a number of crimes that would pertain to young people that threw them into the system. They no longer face that possibility. So we're ensuring that they are able to thrive in those very, very formative years. So, when I think about social inclusion and what your charge was, and law and the literacy, and how do we create a better system, it is important for us that we look at every child, regardless of race, regardless of ethnicity and gender or whatever their social status is, to ensure that they are afforded the opportunity to be judged fairly and to be living in permanent and stable homes. I see the juvenile justice system and child welfare system. I hope you see that I'm lit up by this area. It's not for everybody, but I see what work can be done in this area. I see it as the first line of opportunity to help these young people, to help these families become contributing citizens, world citizens, not only local citizens, and that each of us are stakeholders in that. Teachers, social workers, police, we have a part to play in a young person's success. So we must continually educate ourselves, and I'm honored and feel privileged to be in this conversation so we understand from each other how best we can contribute to the well-being of children, because it takes a commitment, it takes courage, it certainly takes the community. And, you know, when we think of, when I look at peace and a sustainable development in our world, I see it, what better place than to start than educating the next generation, and not only book smart and educating in that, but educating them to be tolerant, educating them to be respectful to each other, and above all, educating them to be kind. Thank you for the opportunity to be heard.
Thank you. I would like to also now welcome another guest of ours and guest of honor, His Excellency Ambassador of Oman, Mr. Khalifa Ali Al-Harithi. Thank you very much for your presence with us here, Ambassador. And I also, wait, Salma, just a little bit, would like, would like to acknowledge another guest who has to go now to the airport and leaving us early. Also, her name is Mrs. Salma Al Thani from the royal family of Qatar, and she has to now leave to the airport. Hopefully, she'll make it in time because of this weather, if the flight is not canceled. So thank you very much for coming. Thank you. Now it's an honor also to introduce my next speaker, the Honorable Judge Kathy J. King, who was elected to the civil court in Kings County in 2003 after serving 6 years as a civil court judge and acting Supreme Court Justice in 2009, where she presided in criminal and civil court. She was elected the New York State Supreme Court in 2014. Judge King has written opinions on numerous issues and has 15 reported decisions in New York official reports. Her decisions have also been published in the New York Law Journal. She was appointed to the Committee on Fiduciary Appointment by Chief Justice Jonathan Lippman in 2015. Prior to her election to the bench, Judge King served as the deputy clerk to the Kings County Board of Election, where she served the largest voting constituents in the state of New York. She is an active member of the National Association of Women Judges, where she is the past president of the NAWJ in New York chapter, and presently she is the co-chair of the membership committee. Please give her a big welcome.
Ambassadors, my colleagues, ambassadors, my colleagues on the bench, guests, Madam President, I am so honored to be here today. Madam President has put together a phenomenal panel, and I am so proud to be a part of it. And just touching on some of the words that Amy said about the National Association of Women Judges, which is the organization which I met Judge Nectum and Madam President and my esteemed colleague from New Jersey. It has been a life-changing organization for me, both as a woman and as a jurist. The organization has been instrumental in helping me find my voice and empowering me as a woman and a woman jurist. So I am so privileged to be here today. I am going to speak on guardianship. And many of you may not be familiar with the concept of guardianship, which basically means that a third person is or acts to serve on behalf of another who can no longer act for themselves due to a disability, due to an incapacity, or due to age. All of us in this room have had the good fortune this morning of being able to wake up, put our feet on the ground, shower, brush our teeth, eat breakfast, leave our homes, and travel here to listen to this panel. These seemingly mundane tasks under the guardianship law are called activities of daily living, and the inability to perform these acts, as I will further elaborate on, can determine whether an individual's rights to independence will be managed by a guardian or limited by the court. I was a guardianship judge for 5 years, and the majority of cases I heard where a guardian was appointed involve the elderly, those elderly people who did not have a family sometimes, and in cases where the elderly person did have a family, sometimes the family did not agree as to the care that the elderly person was supposed to get. There was a dispute in the family. So the family member came to court for the court to appoint an independent guardian who could make decisions on behalf of that elderly persons. Many cases involve individuals who are disabled. They could be individuals who had a cognitive defect, or a congenital defect as a result of birth. Or the cases involve people who suffered an unforeseen illness or misfortune. The case that immediately comes to mind when you talk about an unforeseen illness is the case of Jane Doe. Jane Doe was a 39-year-old woman from Belarus, Soviet Union. She was married with 2 children, and after giving birth with her 3rd child, without complications, she went home, and a few days later, she began to suffer seizures. The family, who lived in Brooklyn, decided to take her back to the hospital in Manhattan, Beth Israel, because that was the hospital she gave birth at. However, from the time she left Brooklyn to her arrival in Manhattan, she had gone into cardiac arrest and suffered respiratory failure. The hospital failed to timely incubate her, and she was put on life support and remained in a permanent vegetative state for several years. Her husband had to apply for a guardian to manage her. The case resulted in a lawsuit which was settled. The husband needed a guardian, needed the authority of the court to manage her finances, her estate and provide for her care in the nursing home. So there are many cases like that where you leave the house or you leave your home, you don't know what what is ahead of you that day. That is one case. In the United States, the law regarding the appointment of a guardian is basically uniform throughout the 50 states. A court appoints a guardian if a person is unable to manage some or all of his affairs or is physically unable to care for himself. In New York State, the law controlling guardianships is Article 81 of the Mental Hygiene Law, which is tailored to the particular needs of a person. Since the appointment of a guardian basically means that a person is giving up their right to self-determination or independence, the court, in appointing a guardian, tailors the order to that person's specific needs. So, for example, a person may have a procedure in a hospital, and they may have a lengthy rehabilitative process. They have no family. A guardian is applied for. In that case, since the person may be expected to fully recover after that rehabilitative process, the court would only appoint a temporary guardian according to that person's specific needs. In other cases, the court's power to appoint a guardian requires a finding of incapacity. There are two components to a determination of incapacity. First, the person cannot adequately understand and appreciate the nature and consequences of their abilities. And two, the person is likely to suffer harm because of their limitations and the inability to appreciate the consequences of their limitations. There are many cases where, because of the aging process, the individual may not accept the fact or be cognizant of the fact that they cannot do the things that they were once able to do when they were younger, and or the individual is just in denial about the fact that they cannot function in the same capacity. For example, I think of the case of a woman who was an independent woman, lived independently for her entire life, never married, no children, and she developed Parkinson's disease. Over time, her condition deteriorated, but she refused to ask for help because for so many years, over 60 years or so, she was used to functioning independently. So she was in denial about the fact that she could no longer function to the same degree that she could before she had Parkinson's. Now let me get into the proceeding itself, the bringing a guardianship proceeding. The subject of a guardianship proceeding is called an alleged incapacitated person, since the claims made by the person bringing the guardianship must be established by clear and convincing evidence. And this is the highest burden of proof in a civil case. Simply stated, this means that a person cannot just go to court and say, well, I feel that this person needs a guardian because I don't like the way they're acting, or I don't like, I see a minor change in their behavior. The petition must contain specific factual allegations that the person is likely to suffer harm. And that is usually done in collaboration with medical evidence, either a doctor's affidavit or a doctor coming to court to corroborate the petitioner's claims. So clear and convincing evidence. In New York State, once a petition for guardianship is filed, the court is required to appoint a court evaluator or attorney to prepare a report regarding the allegations contained in the petition. And this is important. Again, you are taking away a person's right to self-determination or independence. So this is another layer that the statute provides to corroborate the allegations in the petition. The court looks at whether, before appointing a guardian, the court looks at whether there are advanced directives in place, such as a power of attorney or a healthcare proxy. A power of attorney enables another person to act on an agent's behalf, and they could perform any variety of functions indicated in the power. Banking, they could do real estate transactions, they could represent a person in litigation. A healthcare proxy, again, is the same concept, but involves healthcare. You designate an individual to act on your behalf to make healthcare decisions. Another case comes to mind, and I cite this case because it incorporates all the things that I referred to in the statute. In this case, the matter of Schwartz, the sister of the incapacitated person had a power of attorney, and this power of attorney was executed when this person was his health was deteriorating. He was a 57-year-old rabbi and Talmudic scholar who was bedridden with multiple sclerosis that had been exacerbated by diabetes and leukemia. He required 24-hour-a-day care by 4 home health aides. He was legally blind and had a feeding tube. He couldn't walk, groom, or feed himself. Although he had a power of attorney in his sister, his brother wanted to manage his affairs, and he commenced an action in court to become the guardian of the sister and to have the sister's power of attorney revoked. And this was a very interesting case because of its highly contested nature. I conducted a home visit, and the first thing I did was I spoke to the incapacitated person, and I asked him, if you had a choice of having either your brother or sister take care of you, who would you select? My brother. And why is that, sir? Because the rest of the things he can do that my sister can't. And what can he do? He can take me to synagogue. Now, although he made that representation, I looked at other things. I looked at the fact that he was unable to take care of himself, and the sister, with the power of attorney, had provided him with such a high level of care, using those power of attorneys. I ultimately dismissed the petition because I found that the brother had commenced the guardianship proceeding in bad faith. Guardianship is a worldwide issue and affects the most vulnerable in our society: the elderly, the incapacitated, and the disabled. The International Guardianship Network is a nonprofit and non-government organization. The mission of the International Guardianship Network is to provide support, information, and networking opportunities for guardians, especially for guardianship organizations, courts, and public authorities worldwide, and to put the legal proceedings of the UN Convention on the Rights of Persons with Disabilities into practice. Members include the U.S., Canada, Central and South America, Asia, and Australia. Most of the member countries of this organization provide for the court appointment of guardians, but at the same time, they favor using advanced directives such as a power of attorney or healthcare proxy. China is one exception. In China, the law automatically allows a spouse, parent, or adult children to act for someone who cannot take care of themselves or manage their finances. If there is a dispute between family members as to who will serve, a local village committee or court will decide. It is important that we engage in planning by executing a power of attorney or healthcare proxy so that our wishes or the wishes of loved ones are known. Guardianship is an effective solution, but it puts the courts in an awkward position of second-guessing the desires of an individual, and it is costly. A guardianship application can cost anywhere from $7,500 to $10,000. By engaging in planning, we can ensure an optimum quality of life as we age and in the event of an unforeseen circumstance.
Thank you so much. We had to go to a little bit lengthy, but she had to explain to you how the system works, and thank you for that. It gives me a pleasure now to also introduce to you the Honorable Michelle Gregory. She is from New Jersey State Superior Court, a judge in 2016, after then 40 years of public service of the city of Newark. And she has served as the State of New Jersey Superior Court judge since 2000. There's a little bit somebody did in editing for me. It's kind of funny. Sat in both. Forgive us for that. Yeah. So she sat in both the Chancery Division Family Part as the lead domestic violence judge and the Criminal Division of the Essex Vicinage, and she is the past chair of the Essex Vicinage Minority Concerns Committee. Currently, she serves as the National Association of Women Judges in New Jersey, a chairperson. She is a dear friend, she and her husband. Please welcome her, please.
Do I press this?
Yes.
Okay. Can everyone hear me? Okay. Good afternoon, almost evening. I want to thank President Kadar and her husband, Ralph, for inviting us here. And I want to say good afternoon to the ambassadors, all the honorable and distinguished guests, and all the other individuals who are here to partake in this discussion and this exploration. President Kadar told me that the subject matter was addressing inequalities and challenges to social inclusion through fiscal, wage, and social protection policies for the disabled, the youth, and the aging. And in that regard, I'd like to open my discussion with a discussion on the role of the role of law. The rule of law plays a vital role in advancing the global goals on sustainable development. In that regard, I'd like to share with you some remarks that were presented at the annual conference of the Canadian Council on International Law by Professor Unta Burney, a professor of law in Canada. She expressed that in order for an international legal order to exist, it must provide universally, or perhaps somewhat less ambitiously, put general applicable principles of conduct and interaction. These principles include those that define what counts as law in the first place, and then what enables a disciplined argumentation and justification that is legal in nature. This perspective highlights the traits of legality, and so that the international legal order has emerged from and are maintained by practice. The same is true for particular norms or rules within the legal order. That means that making, maintaining, defending, and changing international law is a collective process, today with many different participants, including but not limited to states, individuals, and the courts. International law, sometimes referred to as interactional law, is surprisingly resilient, and many actors can defend and strengthen it. But when it comes to norms, it is widely challenged, and when they are no longer effectively defended, they will change or decay. The same is true for the principles and understandings that underpin international law itself. This change is inherent and even necessary in law. The stability and resilience of a legal system depend on its capacity to change, even if that change is often incremental and existing rules may prove hard to displace. We may not always like the changes that are brought, or we may be even concerned about new rules and norms that are being promoted. We may be at a crossroads, witnessing a deep, consequential struggle between competing visions of world order. We are witnessing not merely fights around particular rules and institutions, but sustained challenges to the very underpinnings of international law, our rule of law. And that is not entirely unprecedented, since from the beginning of the 20th century, the substance of international law, notably in its assertion of universal values, has been hotly contested. In today's world, given the state of challenges that are present, international law, and more importantly, the rule of law, it is imperative that there is access and no erosion to the rule of law and its implementation. Questions abound. How is this accomplished when it is estimated by many sources, including the International Journal of Education and Literary Studies, that more than 800 million adults in the world are illiterate, the majority of whom are women, and more than 617 million children and adolescents are not achieving minimum proficiency levels in reading and mathematics at school. In the United States, which is considered a highly advanced nation, studies indicate there exists a declining reading performance. And depending on the measurement, the literacy rate changes anywhere from approximately 60 to 85%. Studies reveal that in the United States, the literacy rate has not changed in the past 10 years. According to the United States Department of Education and the National Institute of Literacy, the following statistics outline the state of literacy in the United States. First, 32 million adults cannot read in the United States, equal to 14% of its population. 21% of United States adults read below the 5th grade level. 19% of high school graduates cannot read. 85% of juveniles who interact with the juvenile court system are considered functionally illiterate. And 70% of inmates in America's prisons cannot read above the 4th grade level. More importantly, how is literacy defined given these numbers? Are there universal standards in this fast-paced and changing world powered by the internet and electronic communications? So this begs the question, what is the consequence of all this? Inequality, social exclusion, with a resultant risk of the erosion of the rule of law? Challenges continue to exist in the application of the rule of law. Literacy and access is not the panacea that eradicates this ill. In order to safeguard access, voice must be given to these groups by the establishment of public interest instruments, such as legal aid societies, public defenders, and other public interest entities. In this quest for literacy, these safeguards must be established to ensure the social policies advanced by the rule of law. When we talk about literacy, we must address not only reading literacy, but math literacy. Because mathematics is considered by many a universal language. Those of our society who are more vulnerable, namely the disabled, the youth, and the aging, are at risk to be marginalized, excluded, and forgotten. Literacy is their avenue to ensure access. And given the geographical, cultural, and religious dynamics that exist around the world, literacy and access can prove to be transformative. Now, you've heard from two of my distinguished colleagues about juvenile justice and guardianship. Well, my familiarity is sitting as a judge for 15 years in New Jersey, and I am familiar with the specific laws of the United States and specifically the state of New Jersey. I sat for more than 15 years, and I presided over judicial proceedings in the areas of criminal law, family law, and civil law. And inherent in our legal system is a vehicle for access. However, there still remains shortcomings and challenges. It is not perfect, but it is the best to date, and we have to continue to address many of these challenges. The federal law is the supreme law in the United States and overrides state law whenever there is a conflict. And our laws provide protections under the Equal Protection Clause of the 14th Amendment of the United States Constitution and many enumerated civil rights statutes. Inclusion and remedial action are their hallmark. New Jersey is mandated to enforce both federal and state laws to ensure the aged, the disabled, and the youth of our communities are afforded protection and inclusion, and specifically, and these specific groups have laws that are protective and remedial, such as the American with Disabilities Act, the Education of All Handicapped Children Act, the New Jersey Law Against Discrimination, the New Jersey Law of Conscientious Employees Protection Act, and federal as well as civil rights laws. And in that regard, I'd like to just briefly highlight some of these laws, the protections that they afford to specific groups, and the remedial provisions that are embodied in those laws. The American with Disabilities Laws is one of the most significant federal laws governing discrimination against persons with disabilities. This act prohibits discrimination against individuals with disabilities in employment, housing, education, and access to public services. The American with Disabilities Act, commonly referred to as ADA, provides a comprehensive definition of disability. And I think that that is one of the first avenues that any law that's going to protect the disabled has to define what is a disability. The Education of All Handicapped Children Act promotes the practice of inclusion in public schools and is based on the legal concept of least restrictive environment, defining that educational experience that is most like that received by non-disabled students. This law also takes into account the best interest of the child. And the New Jersey Conscientious Employee Act prohibits retaliation because an employee has taken certain actions or exhibited certain conduct to disclose wrongdoings within the workplace, violations of law, fraudulent or criminal behavior, and other conduct that they believe constitutes a violation of the law. And the New Jersey Law Against Discrimination, commonly referred to as New Jersey LAD, affords redress for the groups we are examining today: the youth, the aged, and the disabled. The New Jersey Law Against Discrimination protects employees in New Jersey from unlawful discrimination at the workplace. New Jersey discrimination laws make it illegal to discriminate against an employee because of their age, ancestry, military service, color, creed, disability, marital status, domestic partnership status, national origin, sex, sexual orientation, or gender identity. It covers both physical and mental disabilities embodied in the Act. And this Act also requires that the employer provide and has a duty to provide reasonable accommodation. Employers must provide reasonable accommodation to applicants and employees who are disabled unless the accommodation would impose an undue hardship on the operation of the employer's business. An employer must participate in an interactive process when an employee makes a request for an accommodation. And also under the New Jersey LAD, it is unlawful to retaliate against persons because of either they opposed any practice or acts, or they filed a complaint or testified or assisted in any other proceeding. Now, I know we're short on time, so I'm going to condense my speech. Yes, okay. So I just want to share with you one anecdotal story about the law against discrimination. I had a case, and it underscores the importance of the law against discrimination. I had a case where there was a litigant who worked for a governmental entity, and she needed an accommodation, she needed reasonable access so she could continue to do her job. She suffered from multiple sclerosis, and she explored the administrative and managerial process to seek redress, and she wasn't afforded the rights and the opportunities under the law as respect to accommodation. So therefore, she sought redress in the courts. And she was successful, but it took a period of years to go through the legal process. And over those periods of years, her employers and failure in compliance in affording her any of the remedies was very difficult. This underscores the need that laws must be protective in nature so that they prohibit discriminatory conduct and practices while at the same time offering a remedial resolution.
Thank you so much, Michelle. Thank you. I was notified that because of security and regulation, we have a new regulation at the UN. We have to finish now. We have an amazing speech by our also Judge Lamb, who did not have a chance to speak, but I am told to close. Totally, totally. So, but we are going, I have an announcement. We are having two events. One is both in March. One is going to be on the 15th of March, and we will be having the sorority coming, and then we will have another one, and that would be for the women parliamentarian of the MENA region. And we're trying to change the law on domestic violence and violence against women. And then we are hosting all the judges from the Association of Women Judges in June, and we will have a very big affair and a big day and more time. So Judge Lam, you'll be speaking there. So give her a big hand, please. Give her a big hand. And forgive us for not having the chance to hear you, but then most of you who follow us have heard Judge Lamb before. She's been part of us for many years. So again, thank you all for coming, and another big hand for all the ambassadors and the speakers.